sexual activity with somebody the day after she had interaction with him, because to show that the argument was that she was bruised, that was inconsistent with the consensual relationship with Kobe Bryant. He was able to introduce that sexual relationship with her boyfriend the next day, because even though that violated the rape shield statute, in theory, it would deprive him of a relevant defense source of injury if he could not have introduced that at trial, and that's why they brought the charges. So, do any of these facts have independent significance such that you should be able to do this? Should be able to make reference to this?
I believe that only that they could bring up is that she slept with one of the men that she met on the dating site, but other than that, I wouldn't think.
So that would be relevant because it's a similar situation. You meet a guy on a dating site, you slept with one of them, you must have slept with me. It's called a pattern of activity.
I didn't consider that, but I was gonna say her interaction with X would be able to be brought in, because what she did could have led to during that, night, and I was gonna say everything else should be, I mean, it's similar situation, but it should be not admissible because it's past.
Yeah, what you're bringing up would go to the issue of consent. But of course, judges have to decide this. Okay, she looked like she was interested, she must have consented.
Well, in the cases of the other people, like, just because she had sex with one of the guys doesn't mean that, like, it was a similar
Well,
situation.
that's the other argument. In making this determination, the court says, okay, what are the benefit? A, you should be able to do this. B, if you can show that it has some significance to your defense at trial, perhaps you should be able to do it. But bottom line, is it too prejudicial? Meaning, would it prejudice the jury against the defendant, which it very well might. And you could make the argument, obviously, always, that those other situations aren't this situation, and you shouldn't be able to bring it in. So it gets complicated. Got all these considerations running around. Okay, at trial, Y claims that during her sexual interaction with X, that she told X that she had to go home and wanted X to end it, and that she did not enjoy this at all. X disputes that this statement was made. X claimed that the music in the apartment was so loud that no one could hear anything. Was Y raped by X after X continued to interact with her after Y asked X to stop? So how about that? What's the issue there?
Withdrawal of consent.
Okay, what do you need for withdrawal of consent? Definitely, if there was withdrawal, X continued to interact with her after Y asked X to stop. So technically, so is there withdrawal of consent here?
Yeah, but he couldn't hear her.
She withdrew, but how about, is that important?
It must be communicated to the
Right. If he didn't hear it, doesn't work because it must be communicated, whether it's true or not. She definitely withdrew consent. He definitely had an obligation to cease interacting with her at that moment, but it must be communicated to the individual. So an individual, so you have control. So woman has prerogative control over her body and sexual preferences, and it's rape whether it's without consent at the moment that the people start to interact or during the course of that interaction, but it must be communicated. So this is an example how little facts become important and you've got to pay attention to them. Okay, so now going back to C, dealing with the intimacy with D, the director. Assume that Y is a very mature and sexually experienced and sophisticated 13-year-old. Y wants to ensure that Y gets a part in the film and seduces D, who is 25. Y tells D that she will accuse D, of statutory raping her if D does not give Y the part in the film. This takes place in Maryland. D tells Y that Y cannot be held liable. This should be D tells Y that Y cannot be held liable. D cannot be held liable for rape because their interaction was consensual and Y seduced him. Is D correct? So in other words, if Y is 13, D is 25, and Y seduces D, can D be held liable for statutory rape?
Yes.
Okay, it doesn't matter, strict liability, more than 4 years difference between the two, doesn't matter who seduced who, doesn't matter what the victim looked like. Strict liability, offense, statutory rape, behavior of the female or male or the underage individual is of no consequence in Maryland. There's no such mistake, not a mistake of law defense, not a promiscuity defense, none of these held liable. So, okay, now does anyone have any questions? Because we've now been over everything.
You didn't go over the last one, would the answer be different if it was 15? So, wait.
Okay, would the answer be different if D was 15 years old? Okay, good point. Does that make a difference?
I would say, yeah.
Under the Maryland statute?
Yeah.
Yeah, that's 4 years.
Yeah.
Right, Maryland, if they're less than 4 years difference, 13, 15, no criminal liability. The theory is that young people will experiment and it makes no sense to put them all in jail. And there's no issue of exploitation of a juvenile as you would or under an ordinary age, a situation of an older female.
I have a question, remember before about approximate cause theory of felony murder? I didn't really get what the difference was approximate cause.
If it's foreseeable, it's probably foreseeable during a bank robbery
If you email me that, I'll
guns
email you my paper tonight.
that
Sounds good.
somebody's gonna die.